Okay, so I am doing this from a different setup. So I'm hoping that somebody can hear me, somebody can see me, and I just ruined my light. Hang on. All right. So let me know if you can hear me. You let me know if you can see me. I am doing this live from Barcelona, and it's a completely different setup. So trying to improvise around making this live for you. So less tech, less lighting, less screen space for me. But my goal with this live is to share a little bit of what's going on with me and with Trademark Factory, and answer your questions about trademarks, about entrepreneurship, about intellectual property, about law, about pretty much anything you want to know. So as we see people joining, I'll do a little bit of intro, and please type your questions in the chat, in the comments. We have a couple of people from Trademark Factory who are going to be helping me make sure that I don't miss any questions that I should answer, and we're going to go from there. So as I mentioned, right now I'm in Barcelona, Spain. Last year I moved from Canada to Dubai as my main base, and right now it's too freaking hot there. So I'm on a 4-month tour, traveling the world, looking at different countries where it's not so hot. Started off in June, and so gotten myself all the way to Spain. Did Turkey, did Serbia, did, what was next? Hungary, Slovenia, Italy, France, Monaco, and now it's Spain, then probably going to do Portugal, and then we haven't figured it all out yet. So I've been trying to shoot some videos that we will be posting on the channel soon from each of those countries. I think a couple already went live, a few more are being edited. So it's quite an experiment and quite an experience for me, traveling with 3 kids, and is really not not easy. It's very challenging from the logistical standpoint, and so that's what I'm doing. The interesting thing that I noticed from the trademarking perspective is that when you go from country to country, especially in Europe where everything's so close, it feels surreal. It feels almost like, I think it was Elon Musk who said that in his opinion it's very likely that we live in a computer simulation. I think I know what he meant, but by looking at this, because you cross an imaginary line on the road, and you find yourself in a country that speaks a different language. The banks are different. The telecom companies are different, mostly, and the gas companies are different. So you really start thinking of whether there's something behind that, as to why there's separation into countries, into languages, and all those businesses that make easy money by by pretty much sitting on things that people gotta buy. And interestingly, with all that, seeing that the brands have even more power when it comes to you going to a different country, because you want to see things that are familiar to you. You want to see brands that are familiar to you. You want to go to places that you know of. You want to, when you're buying apparel, you go to Italy, all you see is brands all over everywhere. But not just Italy. You tend to trust them more. You tend to expect more from them. And I've actually got a personal story. So my very first, when I was still living in Russia as a kid, my first travel abroad was to US. And I remember that was in 1988, 89, something like that. And I remember that I got this guest shirt that was just gorgeous. I loved it. And I got it as a present from the family that I stayed at their house for a month as a exchange student. And I fell in love with that brand. And for years, I've been trying to find a guest shirt that I like. And every time I'd go to their store, I'd look around, couldn't find anything I liked. And I would just say, ugh, and move on. But I kept catching myself thinking about it and just going to their stores every time in every country. And this time around, finally, I closed it off my bucket list, found a few things and guessed that I liked. And but that's really the power of the brand. The reason I kept coming back to their stores had very little to do with the clothes they make now. Had everything to do with the brand and my personal story with that brand, my personal relationship with that brand. And that's why brands are so powerful, because what's the first thing, one of the first words children remember how to say and recognize are brands, right? You drive by McDonald's, they're going to say it's a McDonald's. If you drive by an IKEA, they do the same. And then they, if you have a boy, they'll probably learn all the car brands very quickly. So this is very interesting. This is how brands work, and that's why they're so powerful, and that's why trademarking exists, because businesses realize that if a brand is so powerful, you got to do whatever it takes to make sure you own it and that no one can take it away from you. So that's why trademarking exists, and that's why Trademark Factory exists, to help business owners protect their brands. So that's an observation that I wanted to share with you. The team is still working on all the clients, and that's another share that I wanted to do on this live, is that it's very important when you're building a business to have a team that you can trust, that they will take care of your clients better than you would if you were doing it yourself, and that allows you the ability to kind of I'm not stepping down. I'm still very much a part of this, but it allows you to step away from the day-to-day stuff, and allows you to focus on the growth, allows you to focus on the vision, and allows you to just do what I do. And that's a big part of how we build Trademark Factory. And I think that one of the reasons we have such a great connection with our clients is that so okay, I see the first question. I'm going to answer it in just a moment. I think one of the reasons we have such a great connection with our clients in Trademark Factory is that long ago I stopped seeing myself as an intellectual property lawyer who has this entrepreneurial leaning, and started seeing myself as an entrepreneur who just happens to know a thing or two about intellectual property, right? So, because I see me more of an entrepreneur than an attorney at this point, or a trademark agent or a lawyer or whatever term you can think of, because and that allows me to talk to our clients in the same language, right? I know they don't want to hear legalese, and I know they have a million things that they need to solve, how to do payroll, how to fix their marketing, how to improve their sales, because we're going through the exact same thing, right? Some of the problems we've solved, some of the problems we're still solving, some of the problems we'll still discover we need to solve. But because we're built as an entrepreneurial organization, that's, I think, a big factor to why so many brand owners want to give their business to us rather than go with a traditional law firm, or, God forbid, file their trademark through one of those cheap online companies that will take your money but give you nothing in return. All right, so we got a question from King Joe, and by the way, you're all welcome to post your questions in the comments. I'll answer. I'll do my best to answer all of them. So however long it takes. All right. So question from King Joe: do you know how to fill out a trademark? How do you do it online? So most countries. So I'm assuming you are from either Canada or US. If you're from some other jurisdiction, post in the chat. I'll correct myself, but assuming you're from Canada or US, yes, you can file a trademark by filling out a form online with the Trademarks office. These forms are really poorly made, and they are even worse for those who don't really know what they're doing. Like if you haven't filed at least 50 trademarks, it would be very hard to really know what this is about. Not saying this to scare you, it's just the reality of it. Even us who have filed thousands of trademarks, we still always bitch about those forms being so poorly made, so anachronistic. So they're really difficult to deal with, and it's always very easy to make mistakes, even for us. But we know what to look out for. We triple check everything. So how do you fill it out? Well, there's typically 4 big things that go into the trademark application that you'll need to deal with. Oh, and by the way, so again, I know that the team is listening. Can you guys post in the comments the link to our trademarking checklist? I think that would be a great help for everyone who's watching. So I put together a 17-page checklist on how do you do a trademark, how do you file your own trademark, how to what to look out for, what to look at, and it's really going to be a lot more detailed than what I'm going to share in this video. So Zeke or Andres, if you could post it in the chat, that'd be great. So four types of things that go into your trademark application. First is who's the owner, right? Is it you as an individual? Do you have a company? That kind of thing. Partnerships are a bad idea. Don't file your trademark in the name of a partnership. It's more headache than it's benefit. The second thing you need to decide on is the trademark itself. What it is that you're trademarking. Are you trademarking the name? Are you trademarking the logo? Are you trademarking the tagline? If it's a name, are you trademarking it as all capitals? Are you trademarking it in some weird case? Do you need to provide any disclaimers, any translations, transliterations, all that kind of stuff. If it's a logo, you have to tell them whether you're filing it with a color claim or without it. So that would be the trademark. And by the way, if you have multiple brands, you have to, in most cases, file separate applications for each of them. Don't recommend filing them as a single one, because then the what gets protected would be that combined mark and not the separate elements of it. The third element that you'll need to put in your trademark application in that form would be a list of goods and services that your trademark needs to protect, because trademarks don't give you a monopoly in vacuum. They don't protect your brand forever for everything. They only protect your brand in connection with specific products and services that you claim protection for. So like if you're selling apparel, right, you need to go with class 25. If you're selling, I don't know, marketing services, that'll be class 35. If you're selling educational videos, it's probably going to be 41. It's class 41, something like that. And you need to list specifically what products and services. That's 3. And 4 in US. If you are claiming that you have a trademark that you're already using, then you would need to provide evidence of use, basically showing to the trademarks office that you already have sales of your product, or you already started offering your services under that brand. So there's a specific way to show what's an acceptable specimen of use, what's not, and all of that would need to go on your trademark application. So I'm hoping that this is somewhat helpful, but really, if you're asking that question, how do you fill out a trademark application? My serious answer to you is don't. You're not qualified to do it properly. I mean, unless you don't care about your brand, in which case, yeah, you can give it a shot. And I'm not. There's really zero arrogance in this answer. It's just experience of knowing that if you don't really understand how trademarking works, the chances of you getting your trademark registered are slim and none. By USPTO statistics, 81% of trademark applications get an office action. It's where they say no. And in the end of the day, after all the back and forth, if you consider all the best law firms that file their trademark applications, all the huge companies that file their trademark applications through their in-house lawyers, and also if you consider some of the people who file on their own, only 51% of trademarks ever filed end up being approved. Half of them die. And with self-represented applicants, that number is significantly higher, the number of trademarks that die. So if you really care about your brand, I strongly recommend that you find someone who knows what they're doing to do it for you. All right. Hope that answers the question. Do we have more? Yes. Okay. So I have another question. So Harpoon Motorsports, that's one of our newer clients who actually came to us through YouTube. I remember that. I remember answering some of your questions in the comments. So thanks for joining me live. It's cool to talk to you. So here's your question. I was wondering if Class 35 covers brick and mortar stores on an online retail, but wanted to cover both. Yes. So 35 is for both retail brick and mortar stores and online stores. It's the same concept, but when you file that trademark, and so going back to how you fill out the application, that's what you got to list in your application, that it's both retail stores and online stores. Because some companies do one or the other, some companies do both. For example, some of the older retail stores, that's the brands that were started long before they were any online stores, they would have to file a separate application just to make sure that that their trademark covers not just the brick and mortar stuff, but also online. Because that's another good point. Because with trademarks, after you file your trademark application, you can no longer add anything to it. You cannot add more products. You cannot add more services. You can make it narrower. You can remove things, and you can make things more specific, but you can't expand. And that's how some of the brands end up with hundreds and hundreds and hundreds of trademarks, because they just keep adding and adding and adding and adding products and services to the same brand, right? And the question really is at all times, does this really add anything? Like how much of it is ego, that hey, I need 5 trademarks and not one? On the one hand. On the other hand, it's about, does the existing application really not cover enough doesn't give me enough protection for those new services? So if you filed for online store and then you decide to go with brick and mortar, it's pretty close. So you might get away with just one. Ideally, you'd file both, but does it require filing a separate application? Probably not. At some point when you expand, maybe you do some other things. At that point, you might want to add to that second application retail stores and something else. But it's not a big oversight, because no one will be able to successfully file the same trademark in the same class if you only have online and they say, well, we don't do online, we do retail. So hope that answers the question. All right, let's see if I have more questions, because there's a delay. So I'm trying to buy myself some time here. Okay, so we got a third question from Alec Kazarian. Andrei, your business is well organized. I could not have a better experience working with the team. Thank you so much. Portal is fantastic. The process is great, and their communications are well. I don't know. It's not really a question, but you made my day with this. Seriously, because it's really important for me and for the entire team to make sure that that's how we make our clients feel. The reason I came up with Trademark Factory was I knew that law firms really play this game, that they are the gatekeepers of some sacred knowledge, and they really do their business based on scarcity of information. And I wanted to do everything super transparently, and I really wanted to do everything transparently. That starts with the price. That starts with the process that we explain to people that, hey, when you file your trademark, it's not all. Filing is easy. It's the office actions that count. It's the potential oppositions that count. Because I'm not interested in taking your money, getting my foot in the door, and then milking you for more money. I'm interested in giving you what I would like, how I would like to be treated as a business owner, right? I'm not interested in the service. I'm interested in the result. When I go to the restaurant and I order my steak, I'm really not interested, where they get that meat. I'm not interested how long the cook studied for it. I'm not interested in how much time he spent salting. All I'm interested in is when they bring me that plate and I cut it and I put it in my mouth, am I happy? Right? Same thing with trademarks for business owners. They don't care about any of this crap. All they care about is, did their trademark get trademarked? Did their brand get protected? And I wanted to create an experience that runs off of this. And the portal, the client cabinet that you're referring to, that was that was that was the idea that I had. Funny enough, so sharing some backstage secrets here. So during COVID, in the early days, they locked everything down in Canada. It was horrible, and but they allowed the deliveries, and so I ordered myself an Uber Eats, and I really liked how they were showing what happened with my order, right? Basically telling me, hey, we got your order. Now your order is being made, is being prepared. Now your order is being, given to the courier. Now the courier is biking or whatever they're doing to deliver. And then here it is. And I realized that with trademarking, it's the same thing but worse, because unlike you, and the other thing that with that food order, I realized that when I was looking at it and something was being delayed, I realized how annoying it was on the one hand that I was waiting longer than I thought initially, but seeing at which point it got delayed and why it got delayed made me feel significantly better about the whole experience. I realized that's exactly the same way our clients would feel about trademarks. But with trademarks, it's not that you're waiting, 27 minutes for your pizza. It's that you're waiting for a year and a half for your trademark registration. And we wanted to create that transparency to give brand owners an opportunity to know exactly what's happening with their brands, with all the trademarks that we filed for them. So I'm reading some notes from, but again, Alec, thank you so much for everything you said. Like I said, you made my day. I see that we can't post a link. We can't post a link to the checklist. Can we put that as part of the video, just as a text note somewhere? So like we have here, all important links in one place, tmfacts.com. Maybe you guys could create something that will just show on the screen and just go from there. If we have more questions, we can go to that. And I'm just going to keep reading from my internal chat with the team. What people expect when they became a client. Okay. All right. So the thing, I think that's a good thing I could share. The client experience, and Alec and I'm sorry, I don't actually remember the name of someone who owns the Harpoon Motorsports. I know I should, and I'm sure I could ask my team, but I don't want to lie. I don't remember. Thank you both for everything you guys say. You guys are awesome. So I want to talk a little bit about the client experience, the process, and you're more than welcome to chime in. So yeah, Ian, thanks Zeke. See, that's how it works. So Ian and Alex. Alec, thank you. So here's how this works. The whole thing starts with a call with a strategy advisor, and their role on that call is to see what the client is looking for, because in many cases, brand owners have no idea what to trademark, what trademarking is for. Do they need trademark the name? Do they need the logo? Do they need a tagline? Do they need it in one country, in 2 countries, in 77 countries? And this call we provide as an opportunity for brand owners to gain that clarity. Because one thing we realized is that there's a very clear correlation between how much brand owner understands around the trademarking process and how successfully their trademark is going to go through. Because if they have no idea what the process is, if they are not interested in understanding it, they're like, well, here's your money, just go file it and, don't bother me. Most likely, we won't be able to actually successfully help, because we need cooperation and better understanding what the business is, where we can find those specimens of use, all of those things, right? And this requires some education. Trademarking is formulaic, but it's not easy. It's not easy for someone who's never done it before. So that's why it starts with that call, and assuming that we see that there's interest in the proper interest in protecting the brand, and there's interest in how we can do it for the brand owner, then they can start the process with us. And the first thing we do is a comprehensive trademark search that confirms whether or not your brand is trademarkable. Not all of them will be trademarkable. And there are a million reasons why we'd say, you know what, there's a problem. It could be one of those trademarks that was filed before you showed up and said, hey, I want this brand. And it's not just the identical matches that we look at. It's all the similar brands as well, lookalikes, soundalikes, mean-alikes, synonyms, translations, all those other things. And if we see a problem, then we have another call with the client and say, hey, client, we've got a problem. Here's the problem. Here's what we can do about it. And if the client says, well, I was only interested in my first choice of a trademark, we just give them all their money back, and that's the end of it. And if all is good, then we file their trademark. The other thing they can do is they can send us any number of alternatives until they pick a brand that we love and that we tell them is trademarkable. So that's the search. And then what we do is we would draft the application, file their application, and then sit and wait for many, many, many months, depending on the country. So in the US, it's about 9 months wait. I think in Canada, it's over 2, 3, 4 years. Some clients have been lucky. It's just 2 years. We just had Amanda, our head of legal team, message the other day, like as a big surprise, like, wow, Canada is getting so much better. We got the application examined in 2 years, because some of the most recent ones took 3 years or more. Right, so we just wait. We wait for the Trademarks Office to look at this, and when they do, finally, they either say, we love everything about your trademark application, or they're going to say, well, there's something we don't like about your trademark application. And then this back and forth happens when we have to respond and convince the Trademarks Office that what we did is good, or sometimes we need to tweak things to their liking. This back and forth can happen for multiple months, and there's a lot of legal knowledge and energy that goes into crafting those responses. And assuming that we finally manage to convince them they're going to approve the trademark application, it will start a process that's called the opposition process. In US, it's 1 month. I think it's 1 month. Canada, it's 2 months, right? I'm blanking out. So I know in Europe it's 3. So anyway, it's different countries have different opposition periods. I think it's Canada and US. They're both a month, and then Europe it's 2, and some countries it's 3. So anyway, don't hold me to it. But anyway, there's a short window during which anyone can raise their hand and say, oh, please, dear Trademarks Office, don't don't allow this trademark application because it would be detrimental to my rights. And if they do that, there's this whole hearing, and then the trademarks office decides one way or the other. Assuming a trademark survives the opposition period, nobody opposes, and less than 1% of applications actually gets opposed. Then it gets allowed, and then it gets registered, and then you get your trademark registration certificate, and that's the process. So during this whole thing, we in our client cabinet, the clients see everything that's happening, right? So once they purchase the service, they get the link to their client cabinet, and it says there, you got this trademark. Right now, the searching team is searching, and then it's going to say, if there's a problem, it's going to say, well, we're waiting for you to book a call with the legal team, and if everything is well, it's going to say, we are working on the draft of your trademark application, and after it's filed, it's going to say, well, it's filed. We're waiting for the trademarks office to review it, and so on. So, and we also put expected date. That's the thing I stole from Uber Eats because I realized that it's not enough to say, well, we're waiting for the trademarks office to get back to us. Most people who are reasonable, they can't understand why it would take the trademarks office 4 freaking years to look at a trademark application as it is in Canada. But that's the reality of all their backlogs. So what we do is at least tell you this is how long it might take. If it takes less, great, but we'll keep you posted. So, all right. Do we have more questions? I think we do. Okay, Alec. What happens when your trademark is registered in one country, for example, US, but you go to expand internationally and your mark is not registrable there? Can you not? Okay, well, that's a great question. Gonna give you a story. Gonna give you a story from back in my days in while I was still in Russia with the biggest international law firm in the world. One of our clients was Starbucks, and somebody trademarked Starbucks in Russia before they could, and took them 7 years of litigation to get that trademark back. 7 years and a lot of money. The law firm that I used to work for, they were very, 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 very happy with all the billings they've made over the 7 years. But to Starbucks, the legal fees were just a drop in the bucket, really, for all the pain that they've sustained during the 7 years. Because to them, it wasn't just that they were wasting money on lawyers. To them, the biggest problem was 7 years when they couldn't open a single location, when they couldn't sell a single, mug of coffee, so they couldn't, because if somebody trademarks it there, they have the authority, they have the legal right to stop you from coming into that market, and you either try to buy it off of them, you wait for them to to stop existing, or you need to rebrand. And it's tough because the current trademarking system really wasn't built for today's world when everything is so connected. It wasn't built for. Remember, in the beginning of this, I mentioned the goods and services and how you have to specify this and the classes and all of that. Again, the system was perfect for when most businesses were local, most businesses were very specific, and there was very little spillover from one business to the other. It's not the same now, right? Now everything is global, and you start as a as an apparel company, and suddenly you realize that you are into sports. Like another example is Red Bull, right? Started as a drink, now they're everywhere. It's apparel, it's Formula One racing, all sorts of racing. They do so many different things under that same brand. And how do you expand over time? It's really difficult, because you can't own a trademark without using it, because anyone has the right to cancel a trademark if it wasn't used for 3 years. That's the big problem, right? That again, the current trademarking system wasn't built for this. So eventually, I guess they will have to change it to something that accommodates the new reality. But when they do that, I don't know. So in practical terms, if you got your trademark in the US and you decide to expand and you can't have your trademark there, probably you would either need to rebrand for that country, or you would need to try to buy the rights to use that brand in that country. Another example is Burger King. Burger King. So they got their brand trademarked pretty much everywhere, except they couldn't in Australia. So in Australia, they're known as Hungry Jack, right? Hungry Jacks. It's nothing to do with Burger King. Well, simply because somebody trademarked Burger King there first. And you also see this often with car brands. So certain car model, also they get trademarked. And sometimes the name is not available in some jurisdictions, so they come up with a different title there. Sometimes this happens with beer brands, like happens all the time. Of course, it's easier, especially for smaller business, to maintain the same brand globally, because it's really hard. I mean, it's hard enough to promote one brand and get it to the point when people know about it, people like it, people remember it, people buy it, people are loyal to it. Think about doing this, when you have 2, 3, or more brands to develop for the exact same thing. So this is where a lot of planning needs to happen. This is where a lot of compromises need to happen, because again, in my I lost count. So started in 1996 as an IP lawyer. So that's what, 27 year career. I've yet to meet a client with an unlimited budget. Right, I've done work for all the biggest names you can think of, the Google, the Microsoft, Facebook, Apple, Nike. Even they have budgets, even they have limitations, even they have to choose priorities for what they're going to do with their intellectual property. So you just need to decide what risks you are willing to take, and what needs to be done for sure, right? If you like, think about it. You're starting a burger place, right? And let's say you started in, I don't know, California, and you're like, well, I'm going to be the best brand of burgers. What's really important for you is to have that brand in the US, probably Canada, because it's so easy to spill over from one to the other. It just makes it logical. Do you necessarily need to worry about someone stealing your brand in Australia? Probably not, unless you've got investors with such deep pockets that you can sell them the idea, hey, we're going to be a worldwide brand. Well, let's come up with a name that we can trademark everywhere. We had a few clients that basically had a lot of cash on their hands, and they came up with a brand that they think will be global brand. And funny enough is that I tell them up front, like I don't know, you know, this could be an absolutely crazy idea that you're just burning your money, or you could be doing the absolute right thing, because if it does become a global brand like you hope it will, getting it trademarked now, when it's so easy, when you're not competing with anybody, is the easiest and the cheapest way to do it. But if you know, if all you are is just a dreamer who likes the idea, like, hey, you know, I'm gonna own a global brand, but you're not going to be able to build it into something that people care about, well, then it's on you. But I hope this answers your question, and I try to, you know, give a bit more than just a direct answer. Okay, what do we have? What do we have here? Do we have more questions? Hang on. Okay. So Ian, I was curious about company logos, but one of a designer, and he signed over the ownership over to me. Is the copyright powerful enough to stop someone from stealing the logo? Okay, great question. First of all, there's a video, my video on YouTube, where I explained the difference between copyright, patents, and trademarks. It's probably a good video to watch. There's a lot of details there. So logos is the only type of intellectual property when there's an overlap between two, which is copyright and trademarks. So copyright protects the image as a piece of art, as an artistic expression. Trademarks protect the image as a symbol of products and services. And with that, you did the right thing that you had the designer sign off, because if you didn't, they could, you know, come back and say, well, you don't own this. So that's correct. Then, having said that, copyright by itself is not enough to help you protect the image as a brand, because you're not selling it as an image. You're going to be having products that have that logo on them, and it's not that you're going to be selling pictures with your logo in a frame, and for that, copyright would be perfect. You know, posters with the logo, but I'm just trying to think of something. So Apple, Apple's logo, I have a phone somewhere. I can't find it. You know, it's an image, obviously, or Nike, right? Has some artistic value, but by owning the image as copyright doesn't mean you own the trademark, not at all. So in case of logos that you didn't design yourself, you want to have the agreement with the designer that says the designer assigns all rights in that image, all copyright to you as the company, and then you file that trademark as a logo to protect it as a design mark. So two different things. Okay. Do we have more questions? See, we have this delay, so we're trying to manage it here with the team in semi-real time. Come on, guys, give me the new question. Give me the new question. I don't know what to do. All right, so I'm just going to read it off our internal chat, and then hopefully we can add the question to the actual to the actual screen. All right, but before I answer, so Zeke, the reason I move the stuff is because I don't see the question, right? I only have one screen here, so that's why I need to move it. Sorry. So here's a question from, that's going to be fun reading. Danielle, should I try? Okay, let me, it looks Swedish. Street, I'll try. Streethaftig. I hope it's more or less closed. Okay, so just join. I'm very curious. What would be the investment to get reasonable worldwide coverage for a trademark? Ooh. Worldwide, you're looking at over 100K. With the government fees, with our fees, yeah, it's going to be well over 100K. Even when we file with Madrid application. So when you file in so many countries, there's this convention, international treaty. It's called Madrid Agreement and Madrid Protocol, where there's a lot of countries, over 100 countries, that allows you to file one application in one language and just specify the countries where you want that protection to happen. It doesn't cover every single country, but most of significant countries are there. There are some that aren't there. You have to file directly. It's not a good idea to use the system when you only go for like 3-4 countries because it's cheaper to do it directly, and it's more secure to do it directly. Because the problem with Madrid trademarks is that if something happens to your trademark in your home country, and you always have to start with your application in your home country. So if something happens to that trademark, it doesn't get registered, gets opposed, it gets canceled. If that happens within 5 years of you filing your international application, all of your international trademarks die. So it's very risky, but it makes sense if you want to do worldwide coverage. Most companies, like unless you're Nike, unless you're Apple, when you have insane budgets on IP, you really don't need worldwide coverage. We have a rule, really. There's 4 rules as to how you decide where you need a trademark. So first of all, think of this as a horizon of, let's say, 2-3 years from now. In the best case scenario, where your business is going to be under that brand, right? So first, you file your trademark in your home country. That's where it all starts. It has to, you put goods and services that you feel you're going to be selling 2-3 years from now. Second is all the countries where you make money or where you think you will be making money 2-3 years from now. So to me, a good rule of thumb is 20-30K in revenue from a country. So if you feel that you're going to be generating the revenue from Australia, or you're going to be generating revenue from I don't know, China or France, or I'm just not going to do a geography lesson. But if you feel that you're gonna get the revenue from that country, it's a good idea to get a trademark there. Third is countries where you spend money, whether you have an office there, physical location, or you target your marketing there, right? You run ads, whether it's online or you run TV ads or newspaper ads, whatever, right? So if you have expenditures in that country, and to me the magic number is 5K plus per year. If you do that, also a good idea to secure your brand there, because if you don't, then your risks are much higher. And lastly, the fourth one, if you sell physical products, and if you make those physical products in a country, you gotta trademark it there. So best example, let's say you sell bikes in North America, right? Your primary market is, let's say, US and Canada, Mexico, okay? But you make your bikes in China. You're not planning to sell your bikes in China, but you make them there. The problem is, if you don't get a trademark in China and someone else does, they can prevent you from exporting your own bikes that you made, that were made for you under that brand outside of China. You can't actually take them to US to sell them there, because from the perspective of trademark laws, it is trademark infringement to export a product that bears someone else's trademark. So that's the four, right? So when you say worldwide coverage, I would go through this list and say, you know what? We may be selling here, 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 here. We're probably going to get some money out of there. We'll be spending money here. We'll be making our stuff there. I feel that it's more important to get better protection in the countries that are really important to you than to get weak protection in more countries. Actually, I've never said this. I think it's the first time I formulated this, but it to me it makes perfect sense. Like, if you are a brand, I'd rather you do a good word mark for the name, your tagline, your logo in 7 countries, but really freaking own this so that nobody can even think of infringing on your rights in these 7 countries that are really important to you, than get, let's say, a combined mark that has all of this together just because you want to save money, and file that in 50 countries that you don't even plan to sell in, right? Again, this is not about trademarking. Shouldn't be about ego. It shouldn't be about making you I shouldn't say that. It's not about making you feel good, because it does. When you actually get that trademark registration certificate, something magical happens, and it's valuable. There's tangible value in this, but it shouldn't be about the certificate. It should be about what the certificate represents. So it should be about you loving the idea that you have a brand that's trademarked in many countries. It's about you getting the benefits of having a brand that's being sold in those countries, and that's generating you the fame and the money and the freedom. Right? I hope that answers the question. All right. Okay, so here I mentioned the checklist that we put together, where you can you can download it for free. I think there's just barely anything we ask you to. I think it's just your name and email, something like that, and 17 pages of just plain info about how to file a trademark, what you need to know about it. It's not going to make you into an attorney, but it's going to give you enough pointers that you could use to better understand the process. Again, do I feel that with that checklist you should be filing a trademark yourself? Hell no. But if you don't know the stuff in that checklist and you're hoping to file a trademark successfully, that's an even worse idea. So at least start with a checklist. If you feel you know enough, to do it yourself, you can do it. But I suggest that once you understand what goes into the process, get on that free call with one of our strategy advisors. It really costs you nothing. And in the worst case scenario, all you're going to do is you're going to have clarity around what you need, what you don't need in terms of trademarking. So, and to get on that call, you just go to trademarkfactory.com and there's a big button that says get on a free call, something like that. Do we have any more questions, guys? Is there anything else? Okay, so I see a question from Alec. How do coexistence agreements works? How do coexistence agreements work? Okay, coexistence agreements. So there's different countries treat them differently. But first, let me explain what they are for everyone's sake, so that I'm not being too technical. When the Trademarks Office considers that two trademarks are too close, and one is already applied for, registered, and the second one is yours, the Trademarks Office says, nope, we're not going to allow the second trademark to go through because of that first trademark. And sometimes a good strategy is for the owner of the second brand to reach out to the first brand and say, I think the Trademarks Office is making a mistake. They think that there's likelihood of confusion between us. Why don't we agree to coexist? You do your thing, we do our thing, and we'll have this brand between the two of us. And if they can agree, and if the agreement is worded in a way that that makes it clear that the public is not going to be misled into thinking that that's the same brand, then in most cases the Trademarks Office is going to give a lot of leeway and a lot of they're going to basically they're going to follow the desire of the two brand owners. Excuse me. Some countries are stricter. They say, we don't really care about coexistence agreements. Canada used to be like that. Right now they're opening up to that idea a little bit. But the way it works is you sign the agreement. Usually there's two versions. There's a private version between the two parties. If money is being exchanged, sometimes that happens too. If there's certain conditions that they don't want to make public, then it's with the parties. And then there's a separate version that will be filed with a Trademarks Office by the second brand, and they say, well, we got this coexistence agreement with brand number one. They don't mind that we get our trademark approved. Please do. And they say, we're going to do everything we can to not mislead the customers. And this whole idea of misleading, it's also interesting because trademarks is the only type of intellectual property that actually serves a dual purpose. On the one hand, it protects brand owners from being ripped off by other business owners, by other competitors who are going to use a similar brand to sell similar products and services. But on the other hand, it also protects the public because the policy behind this is that normal people, consumers, when they buy a Nike shoe, or should I say a shoe that says Nike on it, they should feel confident that they're buying a Nike shoe and not a knockoff. Of course, there are those knockoffs everywhere, but at least the law is written in a way that allows Nike, in that case, or brand owners, to go after all those knockoffs. And the idea is not that it only hurts Nike, but also that it hurts the public who may be misled into buying a fake product when they didn't think they were buying a fake product. So that's how coexistence agreements work. We actually had one of our earlier cases. I think we have a testimonial from Andrew Davis with his weapon trademark. One of the earlier trademarks we filed was, still back in the day when I was very active in the day-to-day operations of the company. We filed his trademark, and his trademark was found to be very similar to a brand owned by a huge, massive company that makes sports shoes. You can guess what it is. They recently merged into a huge one, and they just made a movie about him. By the way, great movie, Air. If you haven't seen it, a great movie for business owners. There's a lot of great stuff there. Not as good as The Founder, but really good. So anyway, the story there was that we reached out on behalf of a client to get that coexistence agreement with them, and the arrangement was, the reason I'm sharing all this is because it's all public information. That agreement became part of the file. The agreement was that our client agreed to remove footwear from his application, but they agreed that he'd be allowed to register that brand for clothing, right? Because they weren't selling any clothing under that brand, and he wasn't planning to sell footwear. So even though it's the same class 25, both footwear and shirts and sweatshirts and all of that stuff, they needed that coexistence agreement for the two of them to coexist, and that was one of our biggest wins when I was just starting out, because for us to show that we can get something like this out of a huge company was massive. All right, so here's another question. Ian, would someone be able to sell their own custom motorcycle parts under my same name if it's online? I probably need a bit more context, but really depends on what the trademark is filed under. If the trademark is so again, when you sell parts, there's two parts. There's two issues around this. On the one hand, it's the parts that have the trademark on them, right? It's the thing, and the other part is that selling process. So that's class 35. So depending on what your trademark application covers, if you are worried about someone selling parts that bear your trademark on those parts, and those parts not being made by you, then if you have a trademark that covers the parts, then that's good enough. You don't even need the 35 for that, because 35, the retail sales and online sales, is more about just a web store that can sell anything, whether it's yours or... So I'm going to give you an example for motorcycles. So class 35, if you only have 35, for example, right, the online sales, or retail sales, doesn't matter. And let's say you have Rainbow and Lollipops as a brand. Doesn't matter what the brand is, right? It could be yours, Harpoon Motorsports, or it could be something else, right? So under that brand, you could be selling your own branded parts, but you could also be selling Yamahas and Harleys and anything, right? Because 35 is about the brand of the store. That's what Amazon does. right? So they sell some of their products and they sell some of everyone else's products. That's what 35 is all about. But when you're selling your own parts, each part says Harpoon Motorsports, then that would be the trademark for the class that covers the parts themselves. I hope that answers the question. And if they do made for, that's kind of a gray area when they say, we are blah, 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 but this part fits Harpoon motorbikes. Like I said, this is a gray area. There have been cases decided one way. There have been cases decided the other way. I really don't have the ability to answer that question well enough as part of this live. So here's a question about Supreme. I know we've done a few videos about them. Funny enough, like I don't really have a lot of direct contact with or personal knowledge of what they do, and to me it's just usually just secondhand rumor or me reading some articles about them. So I really don't have an opinion about about what they do. I know they always run into problems with what they do, and they had this fake store in China, and they had some other funny business with their brand. But yeah, I don't want to make more fool of myself than I already did by just pretending that I really know deeply what you're referring to. Yeah, Alec. So, do I know a Torrance Hansen? No, I don't. Okay, what we got? What else we got? So I see there's another question coming up. Just give me 1 second. Okay, so can we help with filing a t-shirt? I'm assuming trademark for a t-shirt, or how much do I personally charge? Well, I don't charge anything. It's the company that charges. You're getting a whole team for the whole process. I do have an account on Clarity if you want a consultation from me, but I don't think that's what the question is about. So I'm not going to even go there. In terms of t-shirts, there's another so King Joe really recommend that you watch a video on this channel about trademarking for t-shirts. That was a long, detailed video, because in some cases you do want to get a trademark that covers your t-shirts. In some cases you don't. Really, it's about whether you're building an apparel brand or whether you think you have a clever tagline or a clever phrase or a clever image that you decided to place on your t-shirt and get that trademark. So if it's a brand, then it's certainly something you should be protecting. But think of this as if you only had your brand at the back, right? On the label, I'm just trying to get the camera, trying to move my hand so you can see the label, right? So if you could see yourself selling your t-shirts that have nothing on them, no images, nothing, just the back label, would there be any value in that? If the answer to that is yes, then it's a brand worth trademarking. If the answer to that is no, because the only reason people would be buying that shirt with a label or not the label, with that brand is because it's big and visible, then maybe not. And I'm not saying that you can't have the brand on the shirt. So, for example, Versace does this all the time, right? They have big words that say Versace, and it's still obviously a valuable trademark, but it's because it's a brand, right? They would still be successfully selling their shirts. The brand would still be valuable, even if it was just a white T-shirt with nothing on it that just says Versace here, or Versace here, something that's barely visible, that's not the ornamental element. So that would be the first thing for you to decide whether you really need a trademark for your T-shirt brand. Is it an apparel brand, or is it just a cute image or phrase for the shirt? If you do decide that yes, it is something that's worth trademarking, again, get on that call with a strategy advisor from Trademark Factory. Will help you. In terms of price, we have the price is posted. We are different from most other firms that offer trademark registration services, is that it's a flat fee that covers everything from start to finish with a 100% money back guarantee. The package that most of our clients go with is $2,600, and that's what it's going to cost you on our end. And there's the government fee that the trademarks office is going to take. It's going to be on top. All right. Alex, how is a particular shoe company able to trademark the bottom of their high heels being red? So, yeah, no one else can have red shoe bottoms. So, yeah, Louboutin did this. And it's funny because his company and, him have had different degree of success with that idea of trademarking red soles in different countries. Some countries say yes, some countries say no, but because his profit margins are so huge, and he sells everywhere, right? It makes sense for him to at least try, because having that monopoly over the collar is super valuable. He started when it was less common. That's how he was able to get some of those registrations. If it was now, it probably would have been much harder. And that's another reason why some countries allow it and some countries don't. So the reason it's allowed is because there's no functionality. There's no functionality to the color, and because it's so recognizable. So that's the whole point of trademarks, right? It can't be functional, and it has to be something that allows the public, the customers, to tell a product of one company from the same product of someone else. So if it's the red sole, then why not, right? It is his trademark, and it's been increasingly hard for him to retain that monopoly, because it's now much easier for people, to make knockoffs that look exactly the same. The technologies are all shared. The machines are all the same, right? You go to some, third world country, you go to their street bazaars, you'll see shoes that are made, the quality it's barely distinguishable from what you see in branded stores, right? And on the one hand, of course, it's great that the quality of the products are closer now, but it's also harder for brand owners because imitation is just so wide open, right? So that's his problem with the red souls. So, but he's trying, and he's right to try. Let's put it that way. All right. Okay. Looks like we've run out of questions. Wow, this was a longer one. That's what she said. So anyway, so I'm really happy that we had this good conversation with you, and I'm hoping that you got some value out of this live, whether you're on this live right now or you're going to be watching it later, and post in the comments whether you want me to do more of these. I'm enjoying doing this. I think it's fun, and I love your questions, and I love finding something in the back of my head to try to give you the answers. So anyway, thanks for showing up. If you're an existing client, again, thanks for supporting me during the live stream. If you're and you know how to reach out to us if you need anything else in addition to what we're already doing for you, or if it concerns your existing applications. We, of course, you have the legal chat in the client cabinet, all of that good stuff. If you're not an existing client and you're thinking about protecting your brand, costs you nothing to book that call with one of our strategy advisors. They don't bite. They're not salesy. They're not going to pester you and with buy. If you feel there's a good fit, they'll make you an offer. If you don't feel there's a good fit, that's fine. But that gives you a good opportunity to ask them the questions that you've had about your specific situation, about your brand, and hear it from us, from someone who actually cares, someone who gives a damn, and someone who wants to help you become a brand that everyone knows about. So that's kind of the mission of Trademark Factory. You will see it on the website. It's to help growth-minded entrepreneurs build amazing brands, and the only way you can build an amazing brand is if you own it. And the only way you can own your brand is by trademarking. So it's kind of a long answer, but that's really what we're all about. So post your comments below, or go to trademarkfactory.com and go from there. So thanks everyone. It's been a pleasure. Signing off from Barcelona. If we choose to do more of these lives, I have no idea what country I'll be in next. So we'll take it from there, one step at a time. So